Good afternoon, everyone, and welcome to today's session on signing documents in the modern era. My name is Samantha Pakirotta, and I'm a lawyer in our corporate and commercial team. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to the elders past, present, and emerging. I will be joined today by my colleague, Senior Associate Eric Kwan. But before we get started, I'd like to go over a few items so you know how to participate in today's event. You will have the opportunity to submit text questions during the webinar by typing your questions into the box found on the control panel. You may send in your questions at any time during the presentation, and we'll endeavour to answer them at the end of the webinar. You'll also receive a copy of the slides and the recording after the event. Finally, we'd also appreciate if you could fill out a short survey upon the conclusion of our presentation. Now let's begin. As part of this webinar, we will explore the topic of execution and look at how the law on execution for individuals, companies and trusts. We will share some practical considerations and implications around signing documents, and we'll finish off with some key takeaways to keep in mind when you're required to sign documents. So what is execution? Quite simply, execution is the act of signing a document. Execution and signing have the same meaning, and we'll use these terms interchangeably throughout the webinar. There are several ways to sign a document. We're all familiar with the traditional form of execution by signing a hard copy document with a pen. This is typically known as a wet signature. Documents can also be signed electronically with an electronic signature known as an e-signature. An e-signature indicates the acceptance of an agreement using certain methods to verify the signer's identity, such as an email address or a phone PIN. DocuSign and Adobe Sign are examples of platforms that use e-signatures. Wet signatures and e-signatures are the two main forms of signatures that we encounter in practice, and they are both acceptable in meeting legal requirements. A digital signature is a specific type of e-signature. Digital signatures provide an extra level of security by using technology that encrypts the signature to verify the identity of the person signing. Digital signatures are typically used in smart contracts and on blockchain. On this slide is a list of legal documents that can be signed. Some of you might deal with these documents on a day-to-day basis, or you may have been asked to sign one or more of these documents in the past. As shown on the slide, a number of documents can be signed, such as agreements, statutory declarations, affidavits, powers of attorney, wills, and deeds. We will explore acceptable methods to sign some of these documents. But first, the next slide provides a brief refresher on the types of entities that can execute a document. For people joining us today, chances are the most common type of entities that you deal with in signing documents are individuals, companies, and trusts. It is also possible for documents to be entered into and executed by partnerships, incorporated associations, and unincorporated associations. A partnership is represented by its partners, so any one of them can enter into an agreement on behalf of and bind the partnership. An incorporated association is much like a company in the sense that it has its own legal identity separate from its members. Some officers of the Incorporated Associations Committee, such as the Treasurer or the President, may be authorised to sign documents that bind the Incorporated Association, but this would typically depend on the Incorporated Association's constitution. In an unincorporated association, certain officers can be authorised to sign documents on behalf of the unincorporated association. But once again, this ultimately depends on its constitution. In this webinar, we will focus on the law on signing documents for individuals, companies and trusts based on New South Wales and Commonwealth laws. It is important to remember that there are different rules and regulations that apply to execution in each state and territory. So moving on to execution by an individual. In New South Wales, the laws that set out the rules for how an individual can sign a document of the Electronic Transactions Act 2000 and the Conveyancing Act 1919. Under New South Wales law, an individual can sign a document electronically, and this includes signing a deed electronically. New South Wales law also allows for the signing of a document to be witnessed remotely via real-time audio-visual technology. Remote witnessing has certainly provided greater choice and flexibility for individuals signing documents. It is, however, important to bear in mind that there are specific procedural requirements that need to be complied with for remote witnessing to be valid. So, what are the requirements for remote witnessing? Well, firstly, the witness must see the signatory sign the document in real time over audio-visual link. The witness must then sign the document or an exact copy of the document as evidence that they witnessed the signature. Another requirement is that the witness must be reasonably satisfied that the document they sign is the same document or a copy of the document signed by the signatory. And finally, the witness must endorse the document with a statement that specifies the method used to witness the signature, and that it was witnessed in accordance with Section 14G of the Electronic Transactions Act. And just a side note here, the signatories and witnesses using remote witnessing do not need to be physically present in New South Wales at the time of witnessing, as long as the relevant document being signed is governed by New South Wales law. One way to check this is to have a look at the document that is being signed. You can often find a clause on the law that applies to an agreement or a deed towards the end of the document. On this slide, we've included an example of an execution panel for an individual. You will see that there is a space for the individual signatory to sign on the right side, and the witness must sign on the left and also provide their full name and address. The endorsement required by Section 14G is shown below the execution panel. And as you can see, the endorsement is a short statement which acknowledges the document was witnessed remotely, the method used, and in this case, the document was countersigned, and that it was witnessed in accordance with Section 14G of the Electronic Transactions Act. Moving on to execution by a company. The rules that set out how a company can sign a document are based on the temporary measures that were introduced in response to the pandemic. Prior to the pandemic, companies could only sign documents using a wet signature. The temporary measures were significant because for the first time, companies were permitted to sign documents electronically and were able to operate as close to business as usual, despite lockdowns and other restrictions that affected business. Many of the practices allowed under the temporary measures became permanent only last month. This is a major positive for companies. It is now a permanent rule that a company can sign documents electronically in two ways. Firstly, by its offices under Section 127 of the Corporations Act, and secondly, by an individual acting as an agent under Section 126 of the Corporations Act. In terms of Section 127, it is the most straightforward and the simplest way for a company to validly sign an agreement or a deed. But what does Section 127 say? Well, the section provides that a company can sign a document without a common seal if it is signed by two directors of the company, a director and a company secretary, or for a proprietary company that has a sole director, that director, where the sole director is also the sole secretary, or the company does not have a company secretary. Now, there are a few things to keep in mind when a company signs a document by its officers under Section 127. The first thing is that the document can be signed by hand or electronically. The company officers do not have to sign in the same format, so one director can apply a wet signature and the other director can sign using an electronic signature. And this is what we mean when we refer to technology neutral signing. Where a company has two or more officers, it can sign a document under Section 127 using split execution. This effectively means that company officers do not need to sign the same document. That is, they can sign two different counterparts, and they do not need to use the same signing methods. For instance, one director could sign a physical copy of the document, and the other director could sign an electronic copy of the same document, rather than the traditional requirement of both directors having to sign the same single physical document. Previously, under the Corporations Act, companies with a sole director and no company secretary could not sign a document under Section 127. However, the recent changes to the law fixes this technical issue and now allows sole director companies to sign documents under Section 127, whether or not the sole director is also the sole secretary. As we know, an alternative way for a company to sign a document is by an individual acting as an agent under Section 126 of the Corporations Act. Previously, Section 126 only dealt with an agent making contracts, but not deeds, on behalf of companies. Now, the Corporations Act allows individuals to sign all types of documents, including deeds, electronically as agents for a company under Section 126. There are a few points to keep in mind when signing documents under Section 126. A lot of the traditional requirements associated with signing deeds have now been removed. As a result, there is no longer a requirement for a deed to be delivered. What this means is that a deed now becomes effective and binding once all parties have signed the deed. It is also clear that agents do not themselves need to be appointed by a separate deed signed by the company. And lastly, an agent's signature on a deed does not need to be witnessed. This slide provides an example of an execution panel that applies in the situation where a company executes a document under Section 127 of the Corporations Act. As you can see, the signature panel allows for two directors or a director and a secretary to sign. If the company only has one director and no secretary, or the sole director is also the sole secretary, that director will sign on the right-hand side in the same spot where Joe Bloggs has signed. It is important to remember that the changes to Section 126 and 127 that we have just discussed do not apply to the signing of documents by foreign and statutory companies, or the situation where the agent signing for a company is another company and not an individual. And finally, the rules that apply to trusts ultimately depend on the nature of the trustee of the trust. If the trustee is an individual, then the rules that we explored a few slides earlier on execution by an individual will apply. However, if the trustee is a company, then the same rules that we considered on the previous few slides on execution by a company will apply to the trust. I'll now hand over to Eric, who will take us through some of the practical considerations and implications of signing documents. Thanks, Eric.
Thanks, Sam. So let's recap on things so far. Documents can be signed. So documents can be signed using a traditional wet signature, an electronic signature, or a digital signature. In order to work out how you go about signing a document, you need to, number one, determine what type of document is actually being signed, and number two, consider who is signing the document and what capacity they are doing this in. Slightly different rules or procedures will need to be followed depending on what you are signing and who is signing it. Okay, so let's talk about the implications if you, for whatever reason, decide to accept a document that hasn't been executed properly in the way Sam was just talking about. Now, the most obvious implication, if you do this, is that you may be unable to enforce the document against the other side. This, of course, depends on what the document is and why you decided to accept it in the first place. So let's look at agreements and contracts first. Now, generally speaking, you have a valid agreement or contract if you can show that all of the contracting elements are there, or more importantly for today, that there is some sort of offer being made and acceptance of that offer, and the parties intended to create legally binding relations. From a contract law perspective, execution or signing is really just one way to show that there is an offer that is being made or is being accepted, and that the parties want to create legally binding relations. As such, the failure to sign something properly may not be entirely fatal to your chances of enforcing that agreement. If anything, the fact that the other side gave you a piece of paper or sent you an electronic document with a signature on it may be just enough to get you across the line from a contract law point of view. The problem, though, is that there may be a reason why the other side couldn't get the document signed properly in the first place, with the most usual scenario being that the person just didn't have the authority to do so. As such, it may pay to dig a little bit deeper and make a few inquiries if the other side are wanting you to accept something that has not been signed properly. Deeds, however, are a different kettle of fish. Although there are several other points of difference between agreements and deeds, historically, deeds were considered a special type of binding promise or commitment to do something without payment or consideration. As such, deeds needed to go through the added formality of being signed, sealed, and delivered. Whilst this terminology is considered more or less legacy nowadays, given the specific statutes in place, the fact that the terminology is still used goes to show that the distinction is still there. So failure to execute a deed properly effectively means that the deed cannot be enforced. Okay, so now let's look at things from the perspective of someone who is presenting an improperly executed document. The fact that you have presented the document may equate to a representation by the signatory about their capacity and their authority. As such, if you were to later claim that you did not have that capacity or authority, then there is an argument that you have misled them and you have not opened yourself not only to a claim of misrepresentation under Australian consumer law, but potentially the company itself. One case that you might find interesting, which illustrates this point, is Knight Frank Australia Pty Ltd and Paley Properties Pty Ltd. Essentially what happened there is a company called Chalice Homes Pty Ltd was looking to buy a commercial property in South Australia. As part of negotiations, one of the two Chalice directors signed a contract for 1.5 million, but in doing so had manually changed the signature panel so that Chalice was noted as signing pursuant to Section 127 of the Corps Act, which requires two director signatures. Obviously, Chalice pulled out of the deal before the second director could sign the contract. Now, the sellers, Paley Properties, eventually did sell the property to a third party for 1.25 million. So they weren't too chuffed about how the whole thing went down in the first place, and ended up suing Chalice and the director that had signed for breach of contract and misrepresentation. The courts ultimately said that the contract was not enforceable, as it had not been fully executed, and there was no case for misrepresentation, as the Chalice director had manually changed the signature panel to make it clear that they were signing under Section 127 and not as agent or representative of the company. Having said this, I think things would have turned out slightly differently had the Chalice director not altered the execution panel the way they did. As such, it may pay to check that you have the appropriate authorities in place before you sign a document for a company, or otherwise make it clear from the get-go how you intend to sign the document in the first place. Okay, so we've talked about the implications of accepting a document which hasn't been executed properly. So aside from the more procedural elements that Sam has already gone over, there are a few practical things to think about after you have pretty much sealed the deal and are now frantically looking to get signatures on paper. The first thing I wanted to talk about is in relation to companies, in particular around the Section 129 assumptions. For those that are unfamiliar with what these are, the Corporations Act effectively allows people to assume that the other side have followed due process if the documents are signed in accordance with Section 127 of the Corps Act. As in, if there are two or more directors on record, the document is signed by two directors or by a company director and a company secretary, or where there is a sole director who is also the sole secretary, or there is no secretary, then by that sole director. Looking at things from the reverse angle, what this essentially means is that if the document isn't signed in accordance with Section 127, you may need to work out whether or not the counterparty has signed the document properly and followed due process. To do this, you may need to ask for a copy of the other side's constitution and review it to see exactly how they are supposed to execute or sign documents, and to check what the process is for the company to make a decision to enter into that contract in the first place. Now, this can be quite a bit of a chore, especially if you have spent a lot of time and effort negotiating a document. Another thing that warrants having a think about when we are talking about companies is in relation to split executions, or in other words, execution by two officers on separate copies of the same document. This is pretty much something that happens day in, day out when you are working remotely and don't want to shuttle paper around. So the general position on this is that if you need two signatures for a document, the signatures should appear in the same execution panel. What this basically means is that one director needs to sign after the other, even if it means one director commits pen to paper literally and the other does so electronically. What is not acceptable, however, is for those two signatures to appear on separate counterparts or even on separate execution panels. Depending on what technical facilities people have at their fingertips, this can sometimes be quite challenging and is probably something which happened quite often at the start of COVID more than anything else. Staying with companies, another way for a company to execute is for someone to sign as their agent, or what we corporate lawyers would call signing under Section 126. Now, if you are looking to accept execution under Section 126, regardless of whether this is done electronically or on paper, you do need to be able to satisfy yourself that the person who is signing has authority, and if appropriate, to keep a record of that authority. In most instances, this will normally take the form of a formal power of attorney or a board resolution. As the other side may not be too keen on sharing internal documents with you, you may need to rely on some other form of apparent authority. An example of this apparent authority may simply be the fact that you have had long-winded dealings or discussions with a director or some other senior officer who appears to have the requisite authority to negotiate and sign a deal, like a CFO or a COO. What you decide to do really depends on the circumstances and whether you think there is any substantial risk that the person doesn't have the requisite authority. But if you are in doubt, or if you think that something is a bit off, you may want to run it by your lawyers or do some of your own investigations. Talking about authorizations, this does lead to a series of corporate governance related issues. In normal circumstances, the board is responsible for the management of a company, which would include making decisions to authorize someone to sign a document to bind the company. To pass such a resolution, you would expect that the board will have considered the arrangement in detail and taken steps to make themselves comfortable that entry into the arrangement is in the company's best interest and will not have the effect of making the company insolvent. So basically in line with their director's duties. This becomes especially important when you are talking about agreements which are financially material to the company, such as an agreement which requires the company to commit substantial resources or capital into a project, or where you are potentially giving up assets as part of a charge of security. Of course, it is possible for the board to delegate some of this decision-making authority to employees, and you do sometimes see delegation authorities or signing authority matrices adopted by companies, especially larger ones, to avoid all manner of transactions having to go to the board for approval. Note that these authorities and matrices do need to be carefully planned and considered by the board, and frequently revisited and fine-tuned to ensure that there is an appropriate balance between operational efficiency and managerial oversight, so that the directors are able to confidently say that they have met their own directors' duties to the companies, even if they have not looked at every single document personally. Another problem that you may encounter is if you need to sign a document in front of a witness, but don't have someone suitable at hand for whatever reason. As Sam mentioned before, there is New South Wales legislation in place which allows individuals to sign documents electronically and for them to be witnessed remotely. There are a few things to keep in mind from a practical point of view if you are wanting to have your signature witnessed remotely. Number one, you will need to be able to positively identify yourself to the witness. This might involve, for example, sending some sort of ID across to the witness ahead of time and then showing them on the camera that ID. Number two, the witness will need to be able to see you and see you actually signing the document. And number three, what you sign should be exactly the same as what the witness is being asked to sign as witness. So putting this all together and assuming that you are using a digital signing platform such as DocuSign or Adobe Sign and intend to use the witnessing function on these platforms, you will need to share your screen as you are signing whilst keeping the video on. Just a reminder also that the witness will also need to make a statement effectively saying that they have done all of this. As such, it is sometimes useful just to pre-fill the execution panels beforehand and share it with the other side to avoid any potential argy-bargy around just the wording. Okay, so to recap, most documents can be signed using a traditional wet signature, i.e. pen and paper, an electronic signature, as in some electronic version of a signature, with some form of authentication attached, or a digital signature, which makes use of some type of cryptography. Depending on what the document is and who is signing, there are different things that need to happen. For example, if the document is a deed, then signatures may need to be witnessed, or if the party is a company which has two directors and it intends to sign under Section 127, then both directors will need to sign. If you are looking to sign or exchange electronically, there are some additional things which you do need to be wary of. This would be, for example, ensuring that a witness, where relevant, provides a statement that they have verified the identity of the signatory and they did witness this signing via audiovisual. And if documents are being exchanged electronically, then you aren't just sending signature panels, but the full document. Okay, so I might check to see whether we have any questions. And if you haven't already done so, you can put them through in the box found on the control panel. So I think we have a question there. Does a picture of someone's wet ink signature affixed to a document constitute an electronic signature? So generally, yes, that would constitute an electronic signature. There will need to be some sort of authentication attached to it, but that's usually in the form of, say, an email or it being exchanged by emails in the first place. I don't think there are any other questions coming through.
No other questions, Eric, and we've just hit our time, so we might conclude.
Okay, so if you do still have any questions, feel free to contact either Sam or me directly. But thank you for attending today's webinar. Once you leave today's webinar, you will receive a short survey on today's presentation, and we would appreciate if you could provide your feedback. You will also receive a follow-up email with a link to view today's recording, along with the slides. So on behalf of Marty Perry, thank you for joining us today and have a great rest of your day.
Thank you, everyone.